All right, so Mr. Lubin, good morning, sir.
Good morning, Your Honor. Mr. Rosenfeld is on also. He's going to argue the motion to quash, and I think Ms. Miller, there she is. Ms. Miller's on too.
Good morning, Your Honor.
Good morning,
Good morning,
Your
Mr. Rosenfeld. Good morning, Ms. Miller. I'm just looking at this for the first time, so just give me a moment.
Sure.
So just filed these a few days ago. This is Sheila Keen Warren. I don't know what page it's on.
We filed a response as well, Your Honor.
Oh, okay. Yeah, just we'll take a few minutes to review this. So just bear with me.
Sure.
All right. Okay. So Sheila Warren, Keen Warren case. So I've read the state's motion to quash subpoena ducus tecum for deposition of Mr. Edmondson, and I've also read the response from the defense. Ms. Miller, anything else you want to add?
Thank you and good morning.
Good morning.
I am standing in today for Mr. Scott. He's had a death in the family. So I did file the motion. I did plan to argue it, but he's not here for that reason. As far as the motion to quash, I'm just going to rely on my written motion. I would like to point out, though, that there has been no assurance or allegation whatsoever by the defense that this deposition of Mr. Edmondson would actually lead to admissible and relevant evidence. The only thing they've put forth is that Mr. Edmondson said there had been no allegations of evidence tampering. So that's certainly not exculpatory. Without some proof of that, without some allegation that this could actually lead to something admissible and relevant, the state objects.
All right. Mr. Rosenfeld, Mr. Lubin, I don't know who's handling it.
Yes, Your Honor. So the state has put forth no legal basis for circumventing 3.220H1A. I know they're speculating that it may not lead to any additional evidence, but Mr. Edmondson's quotes are alarming that he made to the paper in 2000. Specifically, and Your Honor did read it. I don't want to rehash my response, but just this one portion, State Attorney's Office spokesperson Mike Edmondson said the open bags of evidence don't alarm prosecutors. Our only issue is if a defense attorney can successfully raise an evidence tampering issue. This hasn't happened, and then a portion of the quote is not included in the article, so we don't know what else is there. We have complete confidence in Sheriff Newman and the Sheriff's Office. Now, as an officer of the court, I'll represent that we have exhausted every remedy imaginable to try and get additional information on this tampering. For reasons that are privileged, I don't want to go into what we've done, but we have gone above and beyond, and this appears to be, the, I guess, end of our investigation, seeing what Mr. Edmondson knows. Now, the significance of this evidence goes without saying. Your Honor has heard most of the evidence at the bond hearing. The state prosecuted this case after 26 years based on this fiber and DNA. So this is one of the basis for them picking up this case. And, this evidence contamination goes to our theory of defense. It is Brady material. The fact that the state hasn't done anything to disclose anything about this internal audit is very concerning. And again, there's no legal basis for blocking us from speaking to Mr. Edmondson. We're not harassing him. We're not questioning him about policy issues as his role. We're deposing him as a fact witness from a previous position he held 3 state attorneys ago.
So your desire is to simply ask him questions about what happened back in 2000, right?
Yes, we have no desire to question him about what the state attorney's policies are in 2021. We just want to know what he knows about this specific issue.
And why wasn't this motion or this request to depose him done like 2 years ago when you guys had the case for like 3 years, right?
Because the state never disclosed anything about this internal audit to us. I mean, which is, when I claim it's a Brady violation in my motion, their knowledge of tampering should be disclosed. We, and without, again, getting into privileged information, stumbled across.
What is your evidence that they tampered with, that there was a tampering, actual intentional tampering with evidence?
I'm not saying intentional tampering. I'm saying contamination is what I believe. And my evidence is in 1990, this exact evidence was reviewed by PBSO Crime Lab and the FBI, and they did not find a 6 to 8 inch fiber. Exactly what they're looking for when looking at this balloon ribbon. And then after these bags were found open in 2013, this fiber suddenly appears. And based on the information in the article, one of the boxes that was found in the hallway contained the wig.
So you believe that Mr. Edmondson may have some information about what happened in 2000?
At the very least, he could lead us. He might possibly know witnesses we could speak with. I mean, it could lead to relevant information, and that's the standard.
All right. So I'll reserve ruling on this. Unless you, by the way, you have anything else to say?
No, Your Honor.
Okay, Miss Miller.
Only that, given Mr. Scott's family situation, if Your Honor does decide to allow the depot to go forward, it is currently set for Friday. We would like to postpone it until he's able to be back in the office.
I'm gonna agree to that. Take the depositions. If it's gonna happen, it'll happen another day. What I'd like is to wait a few days before I rule on it and see if you guys can maybe reach some agreement upon the parameters of a depot, perhaps, right? If you can't, so I'm gonna wait like a week before I rule on it, okay? I mean, the case is not set for trial until like September, right? So if you guys can reach some agreement, then fine. If not, I'll issue a ruling.
I will reach out to defense counsel on that issue.
Okay.
And obviously,
right.
we're in complete agreement with resetting the deposition in light of Scott's loss.
Right. In light of what? What'd you say, Mr. Rosenfeld?
Oh, I said, obviously, we're in complete agreement with resetting this in light of Mr. Scott's loss.
Okay. All right.
Yeah.
I got you. I didn't hear that. Okay. So, like I said, today is Wednesday today. So I'll wait a week. If you guys reach some type of agreement, great. Let me know. If not, I'll get it rolling out sometime next week. Okay. After Wednesday of next week. All right.
Thank you,
Great.
sir.
Thank you very much, Your Honor. Always a pleasure.
Nice day, everybody. All right. Bye-bye.